Greetings and good morning, at least as far as I'm concerned. I have no idea what time you're watching this video, but today we move finally away from the First Amendment, the speech, press, and religion that I covered earlier. And today I begin the first of a few mini lectures on criminal defendant rights. These would be the Fourth, Fifth, Sixth, and Eighth Amendments. And collectively, when scholars talk about criminal defendant rights, they begin with this notion of due process. And you can follow along in your notes here. The due process means that when the government prosecutes an individual, it must give him or her a set of procedures, that is to say, a process that is fair and civil or due. Now, the problem with this is that the wording in the Constitution can allow for considerable interpretation, and reasonable people can disagree on exactly what that constitutional provision entails. For example, what is a reasonable versus an unreasonable search and seizure in the Fourth Amendment? Or in the Fifth Amendment, what is the difference between a voluntary and a coerced confession, for example? Or in the Eighth Amendment, when the Constitution talks about protection from cruel and unusual punishment. At what point is punishment cruel and or unusual? Now, the concept of due process is associated with the man that I consider the second greatest Chief Justice in American history, Earl Warren. Earl Warren was the three-time governor of California. Warren was a Republican, and Eisenhower nominated him to the Supreme Court in 1953, and he served until 1969. And many people believe that it is Earl Warren's greatest contribution to lay out an impressive array of criminal defendant rights. A lot of the rights in the Fourth, Fifth, Amendments and Sixth Amendments, for example, were incorporated or applied to the states. Now, the thing that is kind of intriguing, and I'll tell you a little story about Earl Warren here, is that Earl Warren got his start as a prosecutor. In other words, he was the man who went out, and it was his job to get convictions of criminal defendants. And so a lot of people are somewhat mystified by why this man who spent a whole career putting bad guys behind bars, why he would be interested in giving criminal defendants a significant array of rights. And Warren himself answered this to a reporter when he said, well, it's because I was a prosecutor that I'm interested in giving criminal defendants their constitutional rights. Warren went on to say that when I prosecuted cases in virtually every circumstance, I, representing the government, had all the advantages. I had a lot more money to prosecute an individual than they had money to defend themselves. I had the government. I had the police department or the sheriff's department, or in rare cases, state or federal agencies to aid in the prosecution of individuals who often were fairly poor, were often fairly poorly educated. In 80% of cases, an individual has a public defender as the person who is representing them. In virtually every case, public defenders have a very large caseload. They have very limited resources, and usually, in many cases, what a public defender is trying to do is merely plea bargain or get a deal for their client to plead to a lesser charge. And so because I had all the advantages as a prosecutor, if we are going to hold criminal justice and have real meaningful criminal justice, then we have to hold the government to the highest standards of accountability. We have to make sure that our police departments are professional, that they act like professionals, and that they do not abuse their power. So this array of criminal defendant rights in the 4th, 5th, and 6th, and 8th Amendments, they don't all come from the Warren Court, but the vast majority of them do. And I will start with the first of those amendments, in the first of the areas in which Earl Warren established significant protection for criminal defendants in the 4th Amendment area. And this has been the amendment that has changed the most over time. The Constitution in the 4th Amendment offers protection from unreasonable searches and seizures. And of course, what constitutes a reasonable versus an unreasonable search and seizure is somewhat open-ended. So in the first case that I have listed in your notes, Mapp versus Ohio, this was a 1961 case. The police were searching for a bombing suspect in Cleveland, Ohio. Dole Ray Mapp was known to cavort around with characters. She kind of liked bad boys. There were thoughts at various times that perhaps there might be a minor narcotics, marijuana might be going in and out of the house. She might be harboring suspects. On another occasion, they thought perhaps a minor gambling operation, a bookmaking operation might be going on. To make a long story short, the police went to her house. They alleged they had a search warrant. There was nothing on it. It was a blank piece of paper. And they searched her home. They didn't find the bombing suspect. They didn't find any narcotics. They didn't find any betting slips. They found some pornographic books, magazines, some lewd photographs, which violated Ohio law, and she was arrested. This case was appealed all the way to the Supreme Court. And the significance of this case, what I want you to know about this case, is that the Warren Court incorporated the 4th Amendment. Protection from unreasonable searches and seizures had always been around for federal authorities. And now Warren said, you too, Ohio, you must respect the 4th Amendment to the same degree as the national government. And what the incorporation of the 4th Amendment meant in this area was an extension of a very famous rule called the exclusionary rule. The exclusionary rule is exactly what its name implies. That is to say that prosecutors cannot introduce evidence that is illegally obtained. And Earl Warren made sure that the police were held to the very highest standards of conduct. For example, if the police used the wrong form, used the blue form instead of the yellow form, Warren would throw that conviction out. If a narcotic was misspelled and it was a variant of the drug rather than the drug itself, Warren would throw out that conviction. And once again, Warren's claim was the government has all of the advantages. The government has the economic resources. The government has professional resources available, and they therefore should be held to the very highest standards of conduct. And throughout the 1960s, the Warren Court held the police to these incredible high standards. In 1969, Earl Warren retires. We get a new Chief Justice, Chief Justice Burger. Chief Justice Burger did not overturn the Mapp precedent. Certainly, the exclusionary rule was still in place, but Burger believed that Warren had gone too far. And so the Burger Court began to slowly relax some of these standards. For example, if the information was correct, but the form used was wrong, Burger said that that's okay. We will allow that. If the yellow form's being used versus the blue form, who cares as long as the information is correct? Burger then extended that to information itself. If, for example, there were simple typographical errors, but once again, a reasonable person understood what was meant on the form, Burger would allow that if we were just talking about simple typographical errors. By the 1980s, Berger was willing to go a little bit farther, and as you can follow along in the second case, U.S. versus Leon, I will tell you first of all what I have written down for you in the notes, and then I want to extend those comments a bit. So the Berger court ruled in this case that there are good faith exceptions to the exclusionary rule. Essentially, the court would allow a search as long as there is a reasonable expectation, and certainly that is very open-ended, as long as there is a reasonable expectation that the officers were acting in good faith. In this case, the error was made by the judge issuing the search warrant, not the officers themselves. And what the court ruled, and what the Berger court ruled, is that officers can reasonably rely on a facially valid search warrant, which does not deter improper police conduct. Remember, the reason for the exclusionary rule was to deter improper police conduct. In this particular case, if the officers did not make a mistake in this search, if in fact this was a mistake made by the judge, in this particular case, there is no improper conduct on the officer's part to deter. The Supreme Court had all the way back to the Carroll case in 1925. The U.S. Supreme Court had ruled in this particular case that individuals have varying amounts of rights under different circumstances. In this particular case, my concern with this case is what is a good faith exception? When is an officer acting in good faith? In this particular case, I think the court made the right decision. I do believe that there was a reasonable expectation on the officer's part to believe that their search was legal or constitutional. But does that extend to other cases? And at what point in this particular case do you allow a search? Now, when I start the next tape, and I want to give you a little bit of an introduction to the third case, the California versus Azevedo case, and this is where I got ahead of myself a little bit by mentioning the Carroll case. In California versus Azevedo, in 1991, we had Supreme Court precedents going back to the 1970s, even during the Berger court years, where the Supreme Court had ruled that the police could not open a closed container, a car trunk, without a warrant. Now, in this case, Mr. Azevedo emerges from an apartment or a home in which the police in Santa Ana know that marijuana is being stored. Mr. Azevedo comes out of this, I believe it was an apartment, puts a paper bag in his car trunk without a warrant, right? In a closed container, a car trunk, and the police decide they're going to search it. They follow him for several blocks. They ask if they can open the car trunk. He says no. They do it anyway. The officers find a bag of marijuana in the car trunk. Now, what's interesting to me about this case is that Earl Warren would never have allowed this search. They would have said, look, you know what the procedure is. You stop the car, you impound it, you get a warrant from a neutral magistrate. That on average takes about 15 minutes. You didn't do that, you lose the conviction. But in 1991, we had a much more conservative court under Rehnquist, and Rehnquist said that the police may indeed search an automobile car trunk if they have probable cause to believe that there is marijuana in the bag. Now, given the fact that they had staked out this house, given the fact that they knew there was drug activity, the Rehnquist court ruled that it was a reasonable search. Now, the point of this isn't whether Warren or Rehnquist is correct, but the point is that the Fourth Amendment reads the same with both. Warren would not have allowed this search, and by the way, I would not have allowed this search, but Rehnquist did. I'm not telling you that Rehnquist is wrong. I think that the Rehnquist standard is just as reasonable as Warren's, but certainly these two have a different view about what a reasonable search is.